what's next on the menu? Let me see here. We got Trump.
Trump.
Oh, Trump. Okay, well, I can do the New York trial, and you can do the stay, because I don't know what's happening with the stay. The New York trial, my good God, they had his expert come out and say, yeah, shame on all of you for bringing this prosecution. It goes back to the fight that I'm having with this guy on Twitter, Ryan Sheed, where people are like, well, he's found guilty, so he must be wrong. And they don't understand, in the fraud trial, in Alex Jones's defamation trial, it was a default verdict that based on alleged discovery violations. They bypassed evidentiary obligations. They bypassed statute of limitations issues. They bypassed all complex, thorny questions of law. Default verdict. Engoron has followed suit of the witch judge in Austin and said, look, I skip all the hearing on the merits. I declare a summary judgment fraud of his evaluation of Mar-a-Lago. And then people say, well, he had a trial, so he must have been found guilty based on the facts. They did not have any meaningful trial on the fraud. They declare fraud. Engoron, nipple judge Engoron and his girlfriend Allison Greenfield. They declare fraud on the evaluation and then proceed to 6 weeks more trial on what? The amount. And Trump's defense comes in and they basically say, this is all garbage. The Deutsche Bank came in and said, we would have extended him the loans, even if we had halved his original self-evaluations or whatever, his own statements. We would have cut them in half, still given him the loan. We did our own due diligence. We're not idiots. We're the Deutsche Bank. We've worked with such clients as Jeffrey Epstein. We know what we're doing. Their expert, Trump's expert, came in and said, look, all of this, the mistakes on the square footage of the condo, big effing deal. It changes nothing. These are innocent mistakes to the extent that they're even mistakes. And then he tried to shame Judge Engoron and everyone for bringing this prosecution. The case is Alex Jones 2.0. It's a steaming pile of judicial dog crap. And then the only question is, where does it go from here? Robert, where does it go from here?
Well, I think in the court of public opinion, anyone that had any degree of independence observing the trial would come to the conclusion that it's a complete crock. I mean, you have some leading experts, leading professors of finance, of banking, the bank itself, the insurance people themselves, the corporate executives themselves. They've all testified the same way, that in fact there was nothing fraudulent about this at all, that they don't even think it was false, that they don't think it was even exaggerated. In fact, the conclusion of one of his experts was, I would have gone higher on Mar-a-Lago, that Trump was actually underestimating its potential value, as can be witnessed now in the marketplace. That, Trump didn't even fully anticipate where that land value would go, and that he understated a lot of his real estate wealth, not exaggerated it. And so you have no fraud case at all. None. Zero, zilt, zunka, nada. And you got a corrupt partisan hack of a judge with his corrupt partisan staff, including his clerk, maybe writing his opinions for him, presiding over a show trial that is an embarrassment to show trials. And so there's no question that he'll still screw Trump, but it increases substantially the probability the Court of Appeals in New York sets it aside. But what it also does is it increases Trump's credibility in the court of public opinion and with all the other courts looking at his other cases. So that when they say, oh, this is it's like Russiagate all over again. It's like Ukrainegate all over again. It's like what January 6th has actually proven to be for those who studied it, which is a fake case after fake case after fake case. And at some point you're like, okay, you can't accuse this guy falsely again and again and again and have any credibility 6 months from now, come election day. They think they can get away with it in D.C. because they have a partisan jury pool, a partisan judge, and a partisan court of appeals. But this week they appealed the denial of immunity. And what I have been suggesting as a strategy now for quite some time, I was glad to see them embrace, which is start filing motions to stay all of these cases until the constitutional questions get resolved, because it would allow the Supreme Court to get involved without even making a substantive ruling. The Supreme Court could step in and say, this all needs to be stayed until we can have a full briefing on the merits, because there's so many big constitutional consequences here. It would allow the Supreme Court to also stop the embarrassment of the judiciary interfering in a presidential election. And then what the Supreme Court could do is wait until see the election outcome and then say, okay, here's how we're going to go. But you always want to give them practical options that don't require them to go full throttle, either with you or against you. Give them something that gets you what you need for the time being. They're now seeking not only an appeal of the immunity order, on the grounds that he has constitutional immunity for the prosecution brought in on both the argument I made about impeachment being a bar, on the argument that impeachment effectively creates double jeopardy risk in this case, but also on the grounds that constitutionally you can't indict the president for doing his job. And so on those three grounds, they're saying this should all be stayed until the higher courts resolve it. So I don't expect the D.C. Court of Appeals to step in because they're a bunch of political hacks, as we saw again this week. But it gives the pretext for the Supreme Court to step in, which is enhanced by seeing these disgraceful proceedings in New York. Now, that leads to the other big decision this week, which was the gag order. The main effect, as Trump's people realized a little bit later, what probably happened is his lawyers told him, just be careful. They're overly cautious. But the reality is the Court of Appeals eviscerated 95% of her gag order because her gag order had no real limits on it at all. Instead, what the D.C. Circuit said is if you're doing something that has the risk of inciting obstructive delaying behavior, or that's your intent, then that speech can be limited, but only as to judicial staff, not as to the court, not as to the special counsel. You can do whatever you want about the court. You can do whatever you want about special counsel. You can talk about witnesses all you want, as long as it doesn't have a legal obstructive intent, purpose, and likely impact. That's already legally prohibited anyway.
I know. So the restraining order, the gag order, says you can't break the law.
Exactly. That's all they really did. Now, there was one place where they tried to blur it. It was interesting to me. They're trying to blur it the same way conservatives are trying to blur the Israeli speech. It's like separate out the Thomas Masseys of the world, who have very legitimate viewpoints you might disagree with, but are not rooted in trying to kill anybody. He's trying to reduce the number of deaths in the world. God bless Joel Pollak. Very smart, very nice guy, but Breitbart shouldn't be doing hit pieces on Thomas Massey. He's one of the most important advocates for liberty interest in the country. In fact, you should call your congressman and tell him to back the Prime Act and all the good reforms that Thomas Massey's trying to pass so people like Amos Miller can make food the way we all want it. That's what Thomas Massey's busy doing. But in the same space here, where they were blurring the line, is they said, well, the president can't say anything, Trump can't say anything about the court staff that will lead to two things: obstruction and delay of the trial because of robocalling the staff, doxing the staff, or harassing the staff. Now, the problem is they're blurring the line on imminent incitement. They don't say anything about, they say this has already happened. It's like, no, Trump hasn't violated any imminent incitement, and they're citing the New York. That is an imminent incitement, right? And you aren't responsible for the consequences of what somebody else does because of your speech. That's never been grounds to legally limit First Amendment. And the three Democratic D.C. Court of Appeals judges, who, again, had to admit that this gag order was so bad they had to eviscerate 90% of it while pretending they weren't eviscerating 95% of it. But they're trying to salvage this little piece of covering up the judicial staff. First of all, doxing's not even illegal, right? If you're a federal employee getting paid, the world should know who you are. That's you're not you don't get to be in secret. We don't have secret courts in America. These judges got to get that through their head. They got to quit doing this. I've been threatened by that with judges, and I have to remind them, your clerk is staff. They get they get taxpayer paychecks. That's who pays them. They're not entitled to anonymity. Just the opposite. The world's entitled to know who's making decisions that impact our lives and our liberties. And so that part's garbage. The other part that's garbage, they don't tie it to imminent incitement. It has to be imminent incitement. It can't be you say something, somebody else does something, we're going to now blame you for that and say somehow it violates gag order.
I hope they go back and arrest Bernie Sanders for the guy who shot up the baseball field in Judge Scalise. Go arrest Bernie Sanders. Something he said did it. And Rachel Maddow while you're at it.
Harris, who said a lot of things that helped light BLM on fire in the summer of love.
Well, she was raising bail for them, Robert. Sorry, can't get angry. She was raising bail to bail out the protesters, the violent thug criminals.
The only BLM people I respected in that were the real thieves. Those are the guys like right there. While the BLM protest, they were breaking off and robbing banks along the way. While the BLM protest, they were breaking off and robbing banks along the way. And I was like, that's that. Yeah, I can respect it. I can respect a real criminal. They understood what the march was about.
What I love is that when they were talking about the riots in Ireland that Conor McGregor caused, whatever, and they said like, oh, some of them are protesting the far right stuff and others are looting stores. I'm like, I don't think the same protesters are protesting the far right stuff and looting stores. Maybe I'm wrong. I don't think I am. But the Court of Appeal has adjudicated on that, restricted it, and I knew that was the angle because the way the news frames it upholds most of the gag order. It knows, when you see that, because that was the news, that that it's materially prejudicial
False.
to the position.
Yeah, it's completely false. They denied most of the gag order. They completely revoked most of the gag order by saying you can't do this speech if your intent and likely effect is to obstruct the proceedings. But by the way, this doesn't apply at all to the special counsel or to the court itself. Only applies to the court staff. And so you can't obstruct the proceeding. No duh. That where they try to blur the line is to suggest if you get people to do mass robocalling deliberately and intentionally with the purpose of delaying the proceeding, then that can be limited. I don't agree with him on that. That's not consistent to First Amendment prior restraint law. That's the grounds he could appeal to the Supreme Court and give an additional opportunity for them to step in and clarify this once and for all. But there was a lot of the media lied about what the DC, even 3 Democratic judges admitted 95% of her order was garbage.
Well, my issue is I don't know how to piece out how it applies to the reality, their order, the way they frame it. It's like, okay, you can't do this.
I do, because I've done these before. And I can tell you, basically, it would be impossible under their current reconstruction to argue that he has violated the order. They would need him to say, "Hey, everybody, please
don't do it, Robert.
Mass
Don't say it.
robocall this particular judicial clerk so that I can stop the proceedings from happening." Right? Something outside of that, they have nothing. There's nothing that's gagged anymore.
Mass robocall is a non-offensive example. I thought you were going to go.
Tell him that, because lawyers are going to be paranoid of what Trump might say, so they're going to say, "Hey, just don't say anything, please." That's what they're going to do.
Well, that is the intended result. It's indirect suppression of speech.
If I was telling him, I was like, "No, you're free to say whatever you want. Just obviously don't do something that obstructs a witness." He knows how to do that.
Let him make an example of it and see what the example goes to. If he tweets out Allison Greenfield, it doesn't matter. I won't say it. Okay, all right, very good.